that violation. But the court didn't stipulate what that remedy had to be. They said that a request for repatriation would be an appropriate remedy, but didn't order the Canadian government to do it. And given that the Canadian government had repeatedly insisted that it would not ask for Omar Khadr's repatriation, the failure of the Supreme Court of Canada to order the government to provide an effective remedy effectively guaranteed that the government would do nothing, which is effectively what it did. In so doing, it raises, I think, significant concerns about the rule of law. One might imagine that when a government is found to have violated the rights of its citizens and a court so declares, that a government would feel it incumbent upon it to act in such a way as to remedy that violation. But in the present case, the current government felt no such compunction and did nothing. And the result of that is not just, of course, damaging to Omar, which it was, but also damaging to the fabric of the rule of law. The idea that the government of a country is subject to the rule of law, that if it is doing something unlawful, it will in fact stop doing that and it will remedy that violation. By its failure to act in the circumstances, the Canadian government flouted the rule of law, and that's something that I think should be of concern to all Canadians, regardless of their particular views about Omar Khadr. So in the result, what happened is that the Canadian government did nothing. The court didn't require it to do anything, and so it did nothing. This left Omar to be tried before the military commission process, a process that had been condemned again by all industrialized states, condemned by the United Nations, condemned widely as contrary to fundamental principles of human rights and the rule of law. In that circumstance, where Omar was about to face what by any external measure would be an unfair trial leading to certain conviction, he entered into a plea agreement with the prosecution, under which he pled guilty to the offenses that he was charged with under the military commission. And under the terms of that plea agreement, he would receive a sentence of 8 years, 1 year of which had to be served in Guantanamo Bay, following which the United States undertook to facilitate his transfer to Canada to serve the remainder of his sentence. Canada and the United States thereafter entered into an exchange of diplomatic notes where Canada undertook to look favorably upon a request to transfer Omar to Canada. And that's where things stand.
Yeah. Would you say the Supreme Court was somewhat negligent in its decision, in the sense that the track record of the government up to that point didn't really, to me, warrant to have good faith in it, and that they should have had more of a stronger demand on the government?
The Supreme Court of Canada justified its refusal to order an effective remedy by invoking the fact that it has discretion to order or not order a remedy, and that it was reluctant to interfere in something that appeared to be the exercise of a foreign relations prerogative on the part of the executive. Although it acknowledged that it had the power to intervene, it had intervened in past exercises of the foreign affairs prerogative, but nevertheless didn't want to do so here. It's difficult in reading the judgment to understand what its reasoning was. It invokes at its highest the fact that it didn't have what it said was all the information before it, but it's not clear what information it required, and one might have thought that if there was information absent, then it would have been the responsibility of the government to provide the information, and failing to provide the information, surely the government should not be rewarded by being exempted from the requirement to provide an effective remedy. So I'd say from a strictly legal perspective, or from a jurisprudential perspective, the reasons that the court gave for refusing to grant an effective remedy seem rather thin. Stepping outside of that, it is the case that the Canadian Supreme Court is sensitive to accusations that it's an undemocratic institution and that it wields power to set aside or overturn the actions of democratically elected government. And so, it has its own legitimacy to worry about. whether its concerns about its own institutional legitimacy were such that it declined to protect the rights of an individual who was subject to grave breaches of charter rights, is certainly a question that anybody can ask and reflect on. I have no better answer to that, in a sense, than would any other observer.
Right. What are the implications of this decision for Canadians traveling abroad?
They should know that the Government of Canada does not believe it has any legal obligation whatsoever to provide any form of consular assistance or protection to any of its citizens abroad. And it should know that, based on this experience, it can't rely on the Supreme Court of Canada in any event to come to the aid of citizens whose rights are being violated by a foreign state where the Canadian government, for political or other reasons, refuses to intervene. It certainly extends beyond the situation of Omar Khadr. The government's position is that it has the power to intervene, and so one might hope that if one is in trouble abroad, that the government might choose to assist one, but it should know that the government's position, it has no legal obligation whatsoever to do anything for anybody.
Interesting. Also, would you say this is actually extended to Afghanistan in the sense, with the Conservatives, the last couple of years, they were implicated in being party to torture?
So the Afghan detainee case is also a difficult one.
Mm-hmm.
In that situation, a case was making its way up through the courts, and the Federal Court of Appeal found that the Canadian government did not have any charter obligations with respect to Afghan detainees because it was outside Canada and the detainees weren't citizens. This decision, I think one could fairly say, it would be controversial as in terms of its jurisprudential, its legal foundation. But the Supreme Court of Canada declined to hear an appeal. So it declined to hear the case and make a ruling about it. So at present, one can only speculate on what the legal position is, or if it would ever come before the Supreme Court of Canada again.
Do you think the Canadian government, for example, should be more legally responsible in terms of its foreign policy? Because it feels like they have sort of almost a free rein to do what they want within the bounds of international law, assuming that it's upheld.
Well, I'm not sure that it feels constrained by international law. I'm not sure if the government feels constrained by law.
Exactly.
It may feel constrained by politics and by where it can seek and attain political advantage and where it might suffer political harm. But it's not obvious to me that the present government feels constrained by law. Certainly, if I can give you another example that is not about Omar, it's proposing legislation with respect to refugee claimants that would automatically detain refugee claimants for 1 year with no review, with no basis. So, and that would seem flagrantly contrary to the Canadian Charter of Rights and Freedoms, a variety of international instruments legally binding on Canada. And it wouldn't appear that the government understands law to be a constraint on the exercise of its power.
So what does that say? Is it acting like almost in a Darwin state? Survival of the fittest? Almost an anarchy state?
Well, I think it understands itself as answerable at the ballot box.
Right.
But that's a different kind of constraint than answerable in a court of law.
Yeah. The problem with the foreign, too, is you could argue that it could be more secretive.
Well, certainly it's easier to, one of the things about the actions that a state takes abroad is, of course, that courts in Canada are often not accessible to people abroad who might be affected, and Canadian courts might not have jurisdiction over the actions of Canadian officials abroad in all circumstances.